Good afternoon. It is my great pleasure to welcome you to the 28th Annual Fairchild Lecture. My name is Margaret Raymond, and I'm the Dean of the University of Wisconsin Law School. This lecture series recognizes and honors Thomas Edward Fairchild, who served as a judge on the U.S. Court of Appeals for the Seventh Circuit from 1966 until 1981, and then a senior judge from 1981 until his death in 2007. Initiated by Judge Fairchild's former law clerks, the lectureship brings to our law school a distinguished member of the profession from the bench, bar, or the academy to speak on a topic of importance to the profession. Judge Fairchild was born in Milwaukee, Wisconsin, and graduated from Cornell University. He attended this law school, graduating in 1938, practiced law in Portage, Wisconsin, served as an attorney with the Office of Price Administration during World War II, and practiced with the Milwaukee office of Foley and Lardner. In 1948, he was elected Attorney General of Wisconsin, and in 1951 was appointed U.S. Attorney for the Western District. A year later, he resigned to run against U.S. Senator Joseph McCarthy. He was defeated, but was later elected to the Wisconsin Supreme Court, serving until 1966, when President Johnson appointed him to the Seventh Circuit. I have in the past had the great pleasure of sitting with Judge Fairchild's clerks and hearing them share stories about the extraordinary impact this remarkable jurist had on their lives and careers. It is our honor as Judge Fairchild's Law School to continue to recognize him with this lecture series. The law school and I both owe a debt of deep gratitude to the former Fairchild clerks, a group of prominent and dedicated alumni and friends who work very hard to find and entice a distinguished member of the legal profession to give this lecture and speak on important issues facing our society. I would like to thank the clerks, and especially John Skilton, who took a very active and leading role this year in organizing our very exciting lecture. John is a graduate of our law school, an excellent litigator, a tireless and passionate friend to our institution, and he's also going to introduce our speaker tonight. Please join me in welcoming John Skilton.
Thank you, Dean Raymond, and welcome to everybody. I'll make a small correction to the Dean's description of Judge Fairchild's career. Actually, it wasn't Foley and Lardner. It was Miller, Mack, and Fairchild. It wasn't the same Fairchild. There are a lot of stories around that, but I won't go into them. I am honored to introduce William Hubbard, our Fairchild lecturer for this year. William is, I consider, a personal friend. I had the great pleasure of serving on the ABA Board of Governors when he was president, and can attest to his diplomacy and leadership skills. You all have the brochure and can read the credentials that are so apparent. Just let me mention a couple and then bring him to the podium. He's the immediate past president of the American Bar Association. That is a job for a man or a woman that is a full-time undertaking. William did it as well as any bar president I've ever seen. Immediate past president of the American Bar Foundation, again, a distinguished group. Many members are here today of that group. He served as the chair of the House of Delegates in the ABA, and presently serves on the Board of Trustees of the University of South Carolina, and has done so for 20 years or more. But to me, and I'm very pleased and honored to introduce him because he is a lawyer's lawyer. He practices with Nelson Mullins out of Columbia, South Carolina, and he represents the best this profession has to offer. Not only was he a great ABA president, he was a leader of lawyers. And in the speech that you will hear today, you'll understand why I say that. He had the guts to tackle some of the toughest issues presently confronting the profession, most particularly with respect to issues of delivery, pro bono issues, the changing nature of the profession. He created a commission, the Commission on the Future of the Delivery of Legal Services, with a very distinguished group of committee members. It took courage to do that because lawyers are sometimes slow to change, and yet we are confronted with the reality of technology and the change that comes to us as a result of the internet. William will address some of these issues, but he had the courage to do so with the organized bar and lend his name to it, and I am forever grateful on behalf of the profession for your work in that regard. William Hubbard.
John, thank you very much. Before I start this afternoon, I want to thank Dean Raymond for the invitation. We had a good visit in her office a little bit earlier this afternoon. I learned a lot about this law school. I've had a full tour of the campus. It's a beautiful, beautiful university, and we're very proud to be here. I want to acknowledge in the audience Michelle Banky, the treasurer-elect of the American Bar Association. If you think being president is hard, wait till she becomes treasurer. It's a challenge. Bob Gagan, good to see you again. I spoke in Milwaukee last year at a state bar event, and it's good to be back in Wisconsin. And Ralph Cagle, where's Ralph? I saw him a little bit early. Hey, Ralph, thank you for being here this afternoon, and thank you for your leadership of the Wisconsin Bar. I understood that Caroline Avell, who's the president of the American Bar Foundation Fellows, is coming. She might not be here yet, but we look forward to seeing her. Want to acknowledge Christina Plum, the state delegate from Wisconsin, and an old dear friend, Tom Howell, who in his last responsibilities at the ABA was general counsel. So I saw Tom. Tom, thank you for being here. John, thank you for that introduction. I appreciate very much your bearing witness to some qualities, because my wife's here, and it's always good that she be reminded that I'm good for a little something, so I appreciate that very much. John is a great lawyer and a great leader in the American Bar Association, and I was honored when John called to invite me to present the Fairchild Lecture. I was honored, and I was also humbled. I knew of the distinguished list of eminent scholars, practitioners, and judges who have given this lecture on prior occasions, and I'm really not sure I belong in such distinguished company, but I will endeavor to honor their work and honor the legacy of Judge Fairchild. On the official webpage for the Fairchild Lecture, it is stated, for 50 years, Judge Fairchild demonstrated both a scholarly regard for those principles of law that generations have modeled into the American definition of justice and equality, and a remarkable sensitivity to the ever-changing human conditions that make the search for justice and equality an ongoing one. I hope this afternoon to indeed focus on those principles of justice and equality, and especially on the changing human conditions that Judge Fairchild knew that we must consider and adapt to if we hope to maintain and strengthen justice and equality in our great nation. We're facing changing conditions in 4 key areas. 1, the politicization of the judiciary, which threatens its independence. 2, systemic inequality through unequal access to quality education. 3, lack of accessible and affordable civil justice. And 4, deep flaws in our criminal justice system. It is time for courage, strong leadership, and sustained effort. In a recent interview, David Brooks said to Oprah Winfrey that our most important work will not be finished in our lifetime. Indeed, it was Judge Fairchild's recognition that the search for justice and equality is an ongoing one. Let us search together this afternoon, and I humbly hope to provide some light for our journey. It was March 26, 2012. There were people of all colors, all ages. They wore every type of clothing, from T-shirts emblazoned with slogans to running gear to business suits. There were doctors, nurses, medical students in white coats. There were posters and buttons of every size and color. Some people had megaphones, and others tried to outshout their opponents. There was even a trumpeter and a trombonist. It was the plaza of the United States Supreme Court. It was the first day of oral arguments to determine the constitutionality of the Patient Protection and Affordable Care Act, known in the vernacular as Obamacare. It was a cacophony and montage all at once. It was indeed America. Above it all, on the west pediment of the Supreme Court, are the words we know so well: equal justice under law. These words are the embodiment of the justice that we seek as Americans. Justice fairly applied, regardless of class, race, gender, sexual orientation, disability, or station. Having breathed in the fullness of that moment and listened and been surrounded by all the noise and confusion, I sought a quiet place. I walked around the magnificent Supreme Court to the east side. No one was there. It was eerily calm and quiet. I looked up at the pediment. There, above the east side columns, are these words: Justice, the guardian of liberty. All men and women of every class, race, gender, sexual orientation, disability, and station seek liberty and freedom. Liberty and freedom to explore, to learn, to earn, to have a family, to make a difference. It is that yearning for liberty and freedom that gave courage to the barons to confront King John at Runnymede on June 15th, 1215. We were there on June 15th of this last year to celebrate the 800th anniversary. On that date, on June 15th, 1215, Magna Carta was sealed. Liberty was born. Clause 39 of the 1215 Magna Carta is the direct antecedent of the 5th and 14th Amendments, our own country's constitutional guarantees of due process, our country's commitment to equal protection under the law, our country's commitment to justice, the guardian of liberty. These documents, Magna Carta and the United States Constitution, embody precepts of liberty and freedom. But it takes a commitment by lawyers, by judges, and indeed by all citizens to breathe life into these documents and to make them real in the lives of women and men. One of our most venerated jurists, Learned Hand, knew this when he said, "Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it." Though precepts of liberty and equality long preceded the founding of our nation, it is in America that these precepts have been nourished, enlivened, and made manifest in the lives of our people. We should be proud that the American justice system has been and continues to be the envy of the world. Consider the differences in countries without the same commitment. Like the United States, the Constitution of China protects individual property rights, yet Chinese citizens answering the World Justice Project survey rank their country very poorly when asked if the government expropriates without adequate compensation, ranking China 92nd out of 102 countries in the World Justice Project Index, only ahead of countries like Uzbekistan, Venezuela, and Zimbabwe. Or consider Turkmenistan. Their constitution guarantees an impressive array of human rights, far more than are found in the U.S. Constitution. Yet the United Nations has said that Turkmenistan systematically does not respect the right to freedom of expression. Discrimination, restrictions on religious freedom, and limited freedom of association pervade the country. Why are the rights written on paper not realized? Why are they only ink on a page? A lack of judicial independence is a major factor. Courts in these countries are pressured to decide cases in accordance with their government and executive demands. Another major factor is their bar associations are not independent and are, in fact, beholden to the government. As a consequence, they are weak. Lawyers who called for direct election of Beijing Bar Association officers in 2008 were forced to leave their firms. The Chinese government has arrested, intimidated, and harassed lawyers who defend unpopular clients. The former head of the Supreme Court in China said, "The power of the courts to adjudicate independently doesn't mean at all independence from the party. It is the opposite, the embodiment of a high degree of responsibility vis-a-vis party undertakings." These international examples confirm that without truly independent lawyers and judges, the rights written on paper remain just that, ink on paper. At the High Court Symposium at The Hague in July 2013, sponsored by the World Justice Project, Justice Kennedy said this: "Judicial independence is not so we can do what we want, but so we can do what we must." We saw that independence, indeed that courage, in Judge Fairchild's dissent in Ross v. Ebert, 275 Wisconsin 523, stating that if a union restricted membership based on race, that restriction would deny the black applicants the equal protection of the laws. In an interview on February 3rd, 2016, at the New England School of Law, Boston, Chief Justice Roberts expressed concern that people do not have a very good understanding of how the judicial branch is different from the political branches of government, and how the role of judges differs from those in the executive and legislative branches. Chief Justice Roberts continued by expressing concern that the confirmation process is not functioning very well. He noted that in the confirmations of Justice Scalia and Justice Ginsburg, there were only a handful of dissenting votes between the two of them. In the last three confirmations, he noted, the votes were almost strictly along party lines. He said, and I quote, "That doesn't make any sense," end quote. He continued by observing that the process is being used for something other than the qualifications of the nominees, which increases the danger that whoever comes through the process will be viewed in overly political terms. The interview of Chief Justice Roberts was on February 3rd, 2016. Justice Scalia died 10 days later. The politicization of the confirmation process has reached a new level when senators refuse to consider under any circumstances the nominee for the position of Justice of the Supreme Court. Interestingly, today I noticed an article in the Associated Press where Senator Grassley took the Senate floor on Tuesday to take issue with Chief Justice Roberts' remarks in this interview, which again was 10 days before Justice Scalia passed. In my judgment, this stance further causes people to lose confidence in the independence of the judiciary, this inability to even meet or consider a candidate, and further erodes confidence in our most basic institutions of government. Similarly, as we have seen most recently here in Wisconsin, and especially in the state of Kansas, the surge of money to support judicial candidates or to seek to remove judges undermines the public's confidence in the fairness of our courts. Our system is not always perfect in its application. It does indeed falter. But as Supreme Court Associate Justice Lewis Powell said in 1965, while he was serving as president of the American Bar Association, and I quote, "In the final analysis, the only viable alternative to the rule of force is the rule of law." It is incumbent upon all of us, it is our burden and our privilege to ensure that our government and our citizens remain true to the Constitution and to the rule of law. But it has been a journey in our own country marked by great injustices and great triumphs. To overcome slavery, we had to overturn Supreme Court decisions and to endure the greatest human carnage in the history of our country, the Civil War. But of course, that did not end in justice or inequality. It took another great struggle led by Dr. King to give us renewed hope that the dignity of all humans would be respected. It also took great courage by lawyers and judges to bring justice and equality to those long denied. When the U.S. Supreme Court heard Brown versus Board of Education, it actually combined, as most of you know, 5 separate cases into one case and issued a single opinion deciding all 5 of them. One of those 5 cases was a case called Briggs versus Elliott, which arose in Summerton, South Carolina, my home state, and which was tried in the federal courthouse in Charleston, South Carolina, and John and Carmen have been there in that courtroom. Of the 5 cases, Briggs was especially important because it was the only case where one of the trial judges issued an opinion ruling with the African American plaintiffs. Plaintiffs were a group of 20 African Americans, including Harold Briggs from Summerton, South Carolina, in the rural southeastern part of the state. The plaintiffs had children who attended the local public high school for African Americans, and while the school was supposed to be equal to the white public school, it was not, as was the case almost everywhere. The black school had far fewer resources than the white school. The case started out with the plaintiffs simply asking the school board to provide the black school with a school bus like the one given to the white school. The school board denied the black school's request. The federal judge in Charleston who had the case encouraged the lawyer for the plaintiffs, Thurgood Marshall, to go further and to challenge the entire concept of racial segregation in the case rather than simply asking for separate but equal. The name of the federal judge in Charleston was Waties Waring. Judge Waring was a native of Charleston and the son of a Confederate veteran, so he was not the most likely judge to rule in favor of African American civil rights. During his years as a judge, he saw several cases where African Americans were treated unfairly under the law, and his views became more and more progressive. For example, Judge Waring held that it was unconstitutional to pay black teachers significantly less than their white counterparts who had similar education and experience. In another example, Judge Waring issued an opinion requiring the South Carolina Democratic Party, which was the only party that had any power at that time, to permit African Americans to participate in their primary elections. In his opinion, Judge Waring said it was time, quote, for South Carolina to rejoin the Union. Judge Waring was persecuted for his progressive beliefs. A cross was burned in his yard. Rocks were thrown through his window. He received death threats, and the legislature even attempted to impeach him, even though he was a federal judge. After all these cases, the case of Briggs versus Elliott came along in 1951. The trial was held on May 28, 1951, in the federal courthouse in Charleston on the corner of Broad Street and Meeting Street, in a courtroom that is still used to this day. Caravans of African Americans, mostly from Summerton, where the case arose, came to Charleston to see the trial or stand outside the courthouse. Judge Waring watched the crowd outside the courthouse from his office window. He was quoted as saying, as he looked out of the window, "To me, it's awfully heartening when people suddenly sniff a little breath of freedom." The trial was conducted in front of Judge Waring and 2 other judges. The 2 other judges both ruled in favor of the school, requiring the school board to provide more equal facilities to the black school, but refusing to find segregation unconstitutional. Judge Waring disagreed with the other 2 judges and wrote a long dissenting opinion. In his dissent, Judge Waring wrote, "Segregation in education can never produce equality, and it is an evil that must be eradicated." The decision of the court was appealed to the United States Supreme Court. As I said, Briggs was combined with 4 other cases, one from Kansas, one from Virginia, one from Delaware, and one from Washington, D.C. All of the cases involved the question of whether racial segregation in public schools was allowed under the U.S. Constitution. The case from Kansas, as we all know, was entitled Brown versus Board of Education, and the court referred to all the cases under that name. On May 17, 1954, almost 62 years ago, the Supreme Court issued its opinion in Brown, deciding 9-0 that racial segregation in public schools is unconstitutional. The U.S. Supreme Court's opinion draws heavily upon Judge Waring's dissent in Briggs. Of all the 5 cases that made up Brown, Judge Waring was the only lower court judge who argued that racial segregation was unconstitutional. But over 60 years after Brown versus Board of Education, the promise of Brown remains largely unmet. As noted in New York Times columnist Nicholas Kristof in his column just this past week on April 2nd, and I quote, The average white or Asian American student attends a school in at least the 60th percentile in test performance. The average black student is at a school at the 37th percentile. One reason is an unjust school funding system that often directs the most resources to privileged students, end quote. It takes sustained effort over long periods of time to do the really important work. In my state, a close friend and law partner, Steve Morrison, devoted 10 years of his life and significant pro bono time in a landmark public education case entitled Abbeville versus State of South Carolina. Plaintiffs brought the original suit 21 years ago on behalf of poor rural school districts, seeking to hold the state to its constitutional obligation to provide every child the opportunity to acquire an adequate education. In his closing argument before the trial court in 2004, Steve recounted an African parable about babies floating down a river. "We have to get these babies out of the river," a young fisherman exclaimed as he scrambled to pull them out. As an older fisherman began walking away, the young man protested, but the elder explained, "You help as many babies as you can. I'm going upriver to see who's throwing the babies into the river." In other words, we need to focus on the root causes of injustice, not just its symptoms. Steve worked hard on the Abbeville case and sadly died in October 2013. But the efforts of Steve, Carl Epps, and their team paid off. The South Carolina Supreme Court finally ruled for the plaintiffs in November 2014, directing the state legislature of South Carolina to work with the school districts to ensure adequate educational opportunities for all the state's children. This is an obvious victory for equal opportunity. Educational opportunity is also an important issue for the bar because of our commitment to eliminate bias and enhance diversity in our profession and the justice system. To meet this critical goal, we must look upstream at how best to nurture our children's capabilities. More than 60 years ago, lawyers played an important role in securing the decision to make education available on an equal basis in Brown versus Board of Education. Yet despite the valiant efforts of pro bono and public interest lawyers, we are still far from securing the basic right of adequate education on a consistent basis for all children, particularly those from low-income families, children of color, children with disabilities, and others from at-risk environments. The problem is particularly acute in the school-to-prison pipeline, in which disadvantaged students, especially those who need special education or social assistance, are often neglected. Minority students are disproportionately represented in this population as they often attend failing schools, are subject to zero-tolerance policies, and drop out in high numbers if they are not suspended or expelled first. Many become involved with the criminal justice system and are sent to detention facilities. The school-to-prison problem is pronounced in Wisconsin, which ranks 7th highest in the number of student referrals for discipline among the 50 states, according to the Department of Education. Its discipline referral rate of 10.2 students per 1,000 is significantly higher than the national average of 5.8 students per 1,000. Suspension and expulsion from school may seem minor compared to an arrest. However, expulsion is the number one predictor, more than poverty, of whether children drop out of school completely and walk down a road that includes greater likelihood of unemployment, instability, and incarceration. But attorneys in Wisconsin are becoming engaged in a solution to the problem. Diane Rodini Harness of the State Public Defender's Office has tried to address the issue of students having no legal representation in expulsion hearings. Along with several colleagues, she helped form the Student Expulsion and Prevention Project. While the project has no jurisdiction to represent students in expulsion hearings, it does teach volunteer lawyers how to do it, covering the nuts and bolts of expulsion, adolescent brain development, child interview techniques, and cultural awareness. These are civil rights issues and economic issues. Students who leave school permanently frequently are disengaged as citizens, lose earning capacity, become more dependent on public programs, and join the expensive prison population. Nobel laureate James Heckman, of the American Bar Foundation has documented the benefits of high-quality early childhood education as the most economical prevention of these ills. While we work upstream to get to the root of much inequality, the lack of equal educational opportunities, we must work with commensurate energy to address a troubling, persistent, and pernicious problem that continues to imperil the health of our justice system and our nation today, and that is the justice gap. 80% of the poor and approximately 50% of people of moderate means do not have meaningful access to our civil justice system. Chief Justice Gilbertson of North Dakota, President of the Conference of Chief Justices, informed the ABA House of Delegates in February that at least one party is self-represented in 3/4 of the civil cases in the state courts of the United States. 80% of the litigants in family courts are self-represented. According to your own Chief Judge Diane Wood of the Seventh Circuit, over 50% of the appeals in the Seventh Circuit are filed pro se. In landlord-tenant cases, 90% of landlords have lawyers, but only 10% of the tenants have lawyers. In the World Justice Project's Rule of Law Index, the United States ranks 67th of 102 countries on accessibility and affordability of civil justice. All of this when 96 million Americans qualified for Legal Service Corporation legal assistance in the most recent year of available census data. And because of lack of funding, only half of those who seek help from legal services are able to be served. And then there are those who have legal problems but never solicit a lawyer's help. Recent research by the American Bar Foundation by Rebecca Sandifer has indicated that those on the lowest end of the socioeconomic and education scale often do not even recognize their legal problems as legal problems. They simply look at their plight in life as one of lack of success. That's just who I am. I have unfortunate circumstances, and they do not recognize that an eviction notice as a legal process has as a legal process providing certain critical opportunities for relief. Lack of access to justice is a fundamental flaw in the fabric of our democracy. The current system is broken, and we must fix it. The traditional one-on-one model where one lawyer works in person with one client at a time simply has not met the demand of the underserved. In law, we honor precedent, but sometimes we must break from precedent and tradition and seek more effective means to establish justice. We are at an inflection point. We have a choice. We can continue to operate as we have and risk losing the very people we are sworn to serve, or we can engage in fresh thinking and fashion innovative ways to provide legal services to the public. Fresh thinking is what the ABA set out to encourage with the creation of the Commission on the Future of Legal Services. The Commission is identifying and promoting innovations through technology and other means to create new avenues for access to justice, develop new career opportunities for current and future lawyers, and at the same time stay true to our core values of professional independence and client protection. The Commission itself is an influential group of leading innovators, regulators, judges, law professors, and deans, and practicing lawyers from all settings. Our partners include the National Center for State Courts, the Federal Judicial Center, the Conference of Chief Justices, the Association of American Law Schools, and the Legal Services Corporation. Through this collaboration among different perspectives, we are breaking down silos and trying to find new solutions to vexing problems. Justice Brandeis in New State Ice Company versus Liebman in his dissent described how states are laboratories of economic and social and legal reform. No state has historically been more progressive and innovative than Wisconsin. Under Governor La Follette, state government looked to this great university to base policy and legislation on research, evidence, data, and facts. Imagine that. The so-called Wisconsin idea was a good idea then, it's a good idea now, and we need to reinvigorate the Wisconsin idea now, not just in Wisconsin, but in every state in our nation. We need research and evidence to close the justice gap. We must find new delivery platforms based on evidence that meet the needs of the public. To do that, we must experiment. And that is why we're helping to organize community-based grassroots meetings throughout the country that include bar leadership, judiciary and court personnel, local practitioners, local businesses, clients, and innovators. Some of you have been part of these exciting efforts, and virtually all of our grassroots meetings have had significant participation from the organized bar and the state judiciaries, and usually the state chief justices. Last May, the ABA Commission on the Future of Legal Services and Stanford Law School hosted the National Summit on Innovation in Legal Services. The summit more than fulfilled the purpose of cross-pollinating ideas and learning from one another. The message was simple, and at the same time, it was bracing. As we have seen in the medical profession, journalism, finance, real estate, and many other sectors, we must embrace innovation and technology or face the threat of becoming obsolete. We shop differently, we bank differently, we get our news differently. We cannot expect the public to look at the American legal system and not expect it to change if we are going to serve the public. Lawyers can learn from innovators like Rich Barton, founder of several success online companies like Expedia and Zillow. At the Stanford Summit, he reminded us that technology can be a force multiplier, and he urged lawyers to suit up and go to battle with the forces of change and innovation and resist the temptation to fight them. Speakers at the summit pointed out ways to open our minds to innovative approaches using smartphones and tablets and new software, even artificial intelligence, in order to identify new models for delivery of legal services to those who do not have access to legal services. Modria is a company that uses online dispute resolution systems developed by eBay and PayPal and resolves more than 60 million disputes a year outside the traditional court system. Avo is another technology company that provides a variety of services. It receives 8 million hits a month on its website and has addressed 6.5 million legal inquiries. IBM has invested billions of dollars in its Watson project, and recently it has invested another $1 billion to commercialize IBM Watson in several sectors, including the legal sector. A former IBM general counsel has said that Watson is going to take on much more work now done by external lawyers. And state bars are getting more involved, such as the State Bar of Wisconsin, which holds an annual contest called That's a Fine Idea, Legal Innovation Wisconsin, a project that showcases the state's legal innovators. Over the years, it has highlighted original ideas from mobile clinics to e-discovery apps. I also applaud the bar's support of Wisconsin's Equal Justice Fund and the $50 rule. And I commend the Wisconsin Supreme Court for establishing the Equal Justice Commission to look for innovative ways to provide greater access to justice. We've learned from the courts that use online kiosks to serve the public, from law schools that are teaching students to develop user-friendly online and smartphone-friendly legal forms, and from law firms with successful technology-based, non-traditional business models that serve more moderate income clients and keep costs down and still make a profit. The lawyers who seize these and other opportunities see what venture capitalists see. In 2012, investors pumped $66 million into legal technology companies that provide legal services. These are not investments in law firms. They are investments in technology companies. In 2012, that number jumped to $456 million, and in 2014 topped $1 billion. Recent estimates conclude that there are over 1,000 technology companies providing legal services. The bench and the bar have a responsibility to ensure access to justice and protect the public. But we must not be protectionist. The Supreme Court's decision in North Carolina Board of Dental Examiners versus Federal Trade Commissioners makes that point. The ABA House of Delegates passed Resolution 105 at its February 2016 meeting to provide a regulatory framework for those state Supreme Courts and regulatory bodies as they consider the regulation of non-lawyer or non-traditional legal service providers. The framework is designed to protect the public while promoting greater and more affordable access to justice in new ways. Disruptive innovations are accelerating in the legal sector. We know the world changes. As we survey the changing legal landscape, we're reminded of the lyrics sung by Carole King some years ago, "I feel the earth move under my feet." The earth is moving under our feet, but we should not leave it to others to define what the new world will look like. We are at an inflection point. We cannot, to paraphrase Carole King, let the sky tumble down. With the emergence of new technology-based legal service delivery companies, the window is closing on our ability to shape the future. Lawyers have what machines do not: judgment, wisdom, moral values, empathy. And importantly, we are leaders. And it is our time right now to lead. Change can be difficult, but change is inevitable. As Stephen Hawking has said, intelligence is the ability to adapt to change. Failing to seize this opportunity to be better stewards of the public interest is simply not an option. By partnering with innovators in design, engineering, and business, we can deliver our services to clients who are not now getting them and who may not even know we can help them. Justice Scalia made the point so clearly when he said just recently, access to justice is the most fundamental American ideal. We, the people of the United States, in order to form a more perfect union, establish justice. You know these words, you know them by heart. We cannot establish justice when people do not have access to justice. Lack of access creates distrust in our system, and when trust in the justice system is broken, the rule of law is threatened. And when the rule of law is undermined and threatened, our very system of ordered liberty is at risk. To maintain trust in our justice system, we must provide greater access to civil justice. We must also reform our criminal justice system. We are at an inflection point in access to civil justice. We are also at an inflection point in criminal justice. The United States has less than 5% of the world's population and almost 25% of the persons incarcerated in the world. In Wisconsin, the prison population has tripled from approximately 7,000 in 1990 to 22,000 in 2015. We must reform our mandatory minimum laws. We need to give judges the discretion that they need to make smart sentencing decisions. Sentencing reform is happening in the states. As you know, I come from South Carolina, probably not known to all of you as a progressive state in these kinds of matters. But in 2010, miraculously, through a coalition of Republicans and Democrats, we adopted a Criminal Justice and Sentencing Reform Act. Let me highlight a couple of the results in the last 5 years. There's been a 24% decrease in annual admissions to the prison system. There's been a dramatic decrease in the number of nonviolent offenders now in the prison system. And the percentages of nonviolent to violent offenders have almost flipped. Recidivism has declined. And there's been a direct cost savings to the taxpayers of $5 million a year, and that does not even account for the cost savings on capital expansion, not having to build new prisons. So sentencing reform works. The states are about it. We hope more states and the federal government can come along. When Rand Paul and Cory Booker agree on something, you would hope that it could pass the Congress, but so far it hasn't. There seems to be a broader coalition that's developing on sentencing reform, and this is our opportunity. Now is the time to get these reforms passed. I think the evidence is in. These laws work. These reforms work. We must eliminate fines and fees as the primary source for funding local and municipal courts. That structure incentivizes police, prosecutors, and judges in the wrong way and undermines public confidence in the courts. We must provide greater support for indigent defense. Louisiana is facing a 61% budget cut to its already battered public defender program. The National Association of Criminal Defense Lawyers pegs Wisconsin as having the lowest compensation rate in the nation for Sixth Amendment lawyers. Then what happens when sentences are completed? The ABA has developed a new tool to encourage another needed criminal justice reform, the first of its kind online inventory of the 47,000 state and federal collateral sanctions laws that often deny employment opportunities, educational benefits, and even the right to vote for those who have completed their sentences and are released from prison. This database enables judges, counsel, researchers, and policymakers to identify and understand the vast scope of such collateral consequence laws and their effects. This easily accessible information helps lawyers and judges better grasp the implications of plea agreements and sentences. It's a click away at abacollateralconsequences.org. You can go on and you can search state by state, and it has a full inventory of each state's collateral consequences sanctions. My own state has about 715 collateral consequences sanctions or laws. Wisconsin has 693 such laws. Louisiana has 1,483. In our federal statutes, there are a number of these laws that prohibit people from having an opportunity for a successful reentry into society. And 62% of these laws keep people from getting gainful employment after they return to society, having paid their debt, the sentence to which they were sentenced. The Wall Street Journal has paid particular attention to this project. There is plenty of work to do, good work, enough to keep us busy for a long time to meet the changing conditions that Judge Fairchild observed. We must press forward to protect the independence of the judiciary. We must press forward for equality in education, for access to civil justice, and for criminal justice reform. We must move with alacrity. We must move with creativity. As Albert Einstein said, we cannot solve problems by using the same kind of thinking we used in creating them. Several years ago, I had a meeting in Washington that was canceled, and I had a chance to run around the National Mall, and it was one of those picture-perfect days in Washington with a crystal blue sky. I got a little lost on my run, and I came in the back way to the Martin Luther King Memorial. I needed a rest, and I took some time there. And I looked at that 450-foot curved granite wall that marks the monument. I observed the first quote, the one on the far left, the one you all know. The arc of the moral universe is long, but it bends toward justice. The last quote, there are 15 in all, and the last one on the far right of the wall quotes Dr. King's words, "True peace is not merely the absence of tension, it is the presence of justice." Let us sear those words of Dr. King onto our hearts and into our minds. Let us observe the montage and hear the cacophony on the plaza of the Supreme Court when great issues are at stake. Let us join together with new energy and new thinking and renewed dedication to deliver justice not just for some, but for all. Let us also walk on that quiet side and think hard about the future of the legal profession and our justice system. Listen and learn from one another, and act based on the best ideas. Let us be trumpeters and trombonists to the world so that we can do two things, always these two things: promote equal justice under law and advance justice, the guardian of liberty. Judge Fairchild would expect no less. Thank you very much.
I think Mr. Hubbard would take a few questions if we have any.
Have you had any experience with mandatory mediation in civil cases?
Yes.
My experience with it, when you're upstate New York, pro se plaintiffs, because it's mandatory, they have, when you file a civil, have an easier time in getting justice done with that kind of concept.
I think that's generally true. I think any of these alternatives to full-blown trials, or if you can, the purpose of the justice system largely is to resolve disputes, and all of these tools that are available to us. I think what you'll see more and more is, hopefully, I've talked about online dispute resolution. What I hope we'll see more courts involved in is court-annexed online dispute resolution, because I do think our justice system needs to be part of our public fiber. It needs to be part of what our nation is about. And though I think there's some encouragement and some good ideas that come out of these online systems, having the imprimatur of the court on the online dispute resolution system, I think validates those systems in a way and gives the public the assurance that their rights are being protected. Other questions? Yes, sir.
Point number one of your outline was the politicization of the judiciary, and for those of us in Wisconsin, we've seen that right up front for this past week. Do you have any examples of any place around the country where there's been a change of the voting policy that can help us get back to the independence of the judiciary? Right now, in our Wisconsin Supreme Court, I think some would argue we might have two on the left and two on the right, you might argue, but there's a remaining three who are more or less bought and paid for the past few years. And I think that we have a severe problem in Wisconsin about confidence in the independence of the judiciary. How can we get back?
If I could answer that question, I would be a national hero, and I can't answer it because I'm fearful that we're going in the opposite direction. I see more and more influence of money in judicial elections. After the Citizens United case, it basically, the gloves came off, and there are so many institutions in our country right now trying to do what you've suggested, but right now we're swimming upstream. I've seen reports of very wealthy people saying that their next battleground is the judiciary, that they can have a greater influence with their money electing judges than they can even governors, senators, or House members. So this is something we have to be so careful about, and we have to work much harder than we're doing now. And we have to explain to the public the difference, as Chief Justice Roberts said, between the functions of the judiciary, the executive, and the legislative branches. That's why education is so important. That's why civics education is so important. All of this fits together. And we have a lot of work ahead of us, as I said. It's good work. It's hard work, and we may not finish it in our lifetime, but we have to draw a line somewhere. I was encouraged by a Supreme Court, I'm trying to remember it, it was a U.S. Supreme Court case that came out of Florida, where there was a state bar prohibition on judges directly soliciting funds for their reelection. And the U.S. Supreme Court then, I think it was a decision by Chief Justice Roberts, cited Magna Carta for saying that judges should be treated differently. They it's proper to have restrictions on the ability of judges if a bar chooses to have it, or if a state legislature chooses to put those restrictions in place, that's acceptable. It's not a violation of someone's freedom of expression. Any other questions?
Please join me.
One more.
We have one more question.
You referred to the Commission on the Future of Legal Services. Is there anyone from Wisconsin on that commission, and when do you expect there to issue a report or come to conclusion?
Yes. Let me see. I don't know if there's anybody from Wisconsin on it. We do have the Judge Jeremy Fogel, who's the director of the Federal Judicial Center. We have the Supreme Court Chief of the state of Washington, Dan Rodriguez, who's a past president of the American Association of Law Schools, Jim Sandman, the president of the Legal Services Corporation, Mary McQueen, the executive director of the National Center for State Courts. We went to all of these entities and we said, would you send somebody to be on the commission? And what they all said was, I want to be on that commission. I'm going to serve myself. And so bringing those kinds of influential leaders together, I think, has made substantial progress. If you simply Google ABA Futures Commission, you'll see a list of position papers, a wealth of resources, articles that have been written about these trends. You'll also see some issues papers that are currently pending for comment. And we'd love to have your comments on things like alternative business structures, non-lawyer, non-traditional legal service providers, whether or not we should have legal checkups like medical checkups every year, and what should be the protections built into those kinds of processes. It's not easy, and I need to say this, as those people here who have been in the House of Delegates knows, that even trying to put into place a set of principles by which could guide a state Supreme Court in the regulation of non-lawyer providers was deemed to be an implicit endorsement of non-lawyer providers, and it engendered lots of controversy at the ABA House of Delegates. But as I said in my remarks, there are 1,000 companies out there, and the venture capital investment is expanding and increasing annually. I don't have the numbers for 2015. So the message again is, we can't, as I said to my speech in the House about this issue, you can't put the internet back in a bottle. I mean, it's pervasive. It's our life. So we need to lead in a way that ensures that the fundamental values in our justice system are preserved, but at the same time embrace innovation so that we can do a better job of providing affordable legal services to more people. And purely from a selfish perspective, the best studies show about 85% of the American public does not have its legal civil needs met. If you want to look at it just in your own self-interest as a lawyer, that's a big market, and people call it the latent market for legal services. So in a way, if we embrace this innovation and we dip into that market, we'll not only be doing a good thing for the public, but we'll be providing new opportunities for lawyers to help people. And that's what we're supposed to be doing. Thank you.